Greetings. Welcome to the vault. You are now tuned in. Trust Christian, own nothing, control everything. Here's your host. Just want to thank you for tuning in live or listening in the replay. Wanted to bring you some awesome content. Today we're going to be talking about offshore and international business trusts. Get this question a lot in consultations. Get this question a lot on social media. Thank you, Joiner Tia, for tuning in live. Just wanted to answer some questions. This is information that you actually get when you come to our workshop. So we have a workshop coming up in February. Feel free to get on our email list at welcometothevault.com so you can get all the details. It is RSVP. It's not something like conducting the Super Bowl here, but it is something that it is limited seating. It is a private workshop, so there are private things that we'll go over there. It is a workshop, and when you request an invite, the RSVP, you can get that. So once again, go to welcometothevault.com, get on the email list. We'll be sending you that invite so you can actually reserve your space at the actual workshop, and that's going to be at the end of February. So I wanted to talk about the Offshore International Business Trust. And so we're just going to go straight to it. I hear a lot of people say, oh, I have international trust, or I have a foreign trust. And, it really just can't explain some of the details. So, this is what we do at the Vault. This is what we do at Trustee Training. We go over the law. We have no time to put anybody's family or lifestyle in jeopardy, okay? So I'm going to take you all to the law. So when people tell you, oh, I have an international trust, or oh, I have a foreign trust, this is what they're not going to tell you. This is how you know if your trust is valid to operate internationally legally. Okay? This is what you know from trustee training. So we're going to go to the Hague Convention, the United Nations Hague Convention on Trust. H-A-G-U-E, Hague Convention. Okay? So we're going to go to the Hague Convention on Trust because that's the United Nations. That's how you know you can operate internationally. This is a convention that's going to protect wealthy individuals operating internationally, privately, because we're utilizing private contracts. So, here we go. You're going to go to that convention. You're going to see it has quite a few articles. We're going to go to specific articles. This is how you know or you don't know whether you have an international trust document. Okay? 1% of the lawyers, even in the United States, know what is it that I'm getting ready to share today. So, let's go over what they haven't shared with you because they don't know. Article 3 specifically states, the convention only applies to trusts treated voluntarily and evidenced in writing. So, when they first originally wrote this, from mentors sharing this information with me, it was actually a lot more clear. Now it's more vague because the average attorney, if they set up the trust, did you set it up voluntarily? Was the trust created voluntarily? The average individual couldn't explain that. The second thing is it has to be evidenced in writing. So when I hear individuals say, I have a foreign trust, or I have a trust, but it's not written down on paper, it has to be evidenced in writing. They used to say it has to be an express trust, which means it has to be evidenced in writing. Average individual can't tell you that. So, let's go a little bit further. Article 3. Article 3 is critical. Why? Because it has to be written on paper. And it has to be voluntary. If it's not voluntary, then what does that mean? Someone else created it for you. So let's go to Article 6. Okay? Because Article 6 is the applicable law. The first part, we had to find out what type of trust do they even recognize. Article 1, the scope of it, is pretty much the scope, and they're talking about the recognition of the trust. Article 3 is talking about the type of trust. It has to be written, it has to be voluntary, created voluntary. Let's go to the applicable law. A trust shall be governed by the law governed by the settlor. So, does the average attorney know that the settlor, who's the grantor, creates the law that the trust can be written in? Okay? Does the average individual know that? That the grantor can create the law that's applied to it? Here we go. The trust must be expressed, written on paper. They told you that, but they also caveat, it says, or be implied in terms of the instrument. It has to be written, remember? Creating or the writing evidencing the trust. So it has to be written on paper. Interpreted, if necessary, in the light of the circumstances of the case. That's fine. It says, where the law chosen under the previous paragraph does not provide the trust or the category of trust involved, the choice shall not be effective, and the law specific in Article 7 shall apply. So it's telling you that if it's not exactly what Article 6 says, then they're going to automatically default to Article 7. So let's go to Article 7. Where no applicable law has been chosen, that means that the trust instrument actually has to write what law is going to be governed by. A trust shall be governed by the law with which it is most closely connected. In ascertaining the law with which the trust is closely connected, reference shall be made in particular to the place of administration of the trust designated by the settlor, the situs of the assets of the trust, the place and the residence of the business of the trustee, the objects of the trust, and the places where they are to be fulfilled. Now, the average individual does not understand what that means. This is very vague. That's only one article. It's very simple, ladies and gentlemen. This is not legal advice. This is me telling you what you were supposed to be able to go and say, hey, lawyer, can you make sure that this is set up correctly? Once again, the settlor, it says, has the opportunity to create what law is it supposed to be adhered to. Well, what law is it supposed to be adhered to? Do you know that? That's what we go over in trustee training. That's what we're going to go over in the workshop. There are international jurisdictions. Now, going to state, there's this one in here that states that it cannot be created under domestic. They don't deal in statutory entities. They don't deal in domestic entities. If it's from a particular state, they don't allow it to come into their jurisdiction. Okay, so it's very important. Any contracting state, I'm looking for the actual specific. I'll give you the one where it talks about the specific state-created entities, because a lot of people want to operate, say they have an international trust, but really they're just using a domestic trust. And that doesn't mean that that domestic trust can operate internationally, because the convention here does not allow domestic entities to operate internationally in their jurisdiction. They don't want to deal with state-created entities. That's why they said voluntarily. Because if it's a state-created entity, which means it's created under state legislation, they don't want to deal with it. So, that's the long story short, ladies and gentlemen. It has to be utilized in a jurisdiction that's holistic to all the parties involved. Now, when you go to the parties that are involved in this, you will see what type of law that they're all under, or that these entities are operating under. So that is where we come into play, because we understand what type of law it is that they are actually looking for. Here we go, Article 2. For the purposes of this convention, a trust refers to a legal relationship created inter vivos or on death by a person, the settlor, places the assets under the control of the trustee for the benefit of the beneficiary. Okay, well, that's how you get a lot of people saying, well, it can't be a grantor type trust. That's domestic. It can't be a revocable trust. That's domestic. It says where the assets have been placed under control of the trustee. Simple. You have to know how these contracts have to be set up, ladies and gentlemen, in order for them to operate internationally. And that is what we make it a point to educate individuals on, because all we're dealing is in contract law. It's really simple, contract law. So this is what you get when you hear about the offshore trust. They're written in a specific way. Think about it. The average state attorney is only educated in state law. They only have to deal with state-created entities. You have to find someone specifically that knows how to create an international entity. That costs a lot more than somebody creating a state entity. You think? So, ladies and gentlemen, I encourage you all to, either get the consultation from the vault. You can contact us, Christian at trustchristian.com, or you can go to the workshop that we have coming up in February. Once again, you'll email us or get on the email list. I recommend you get on the email list, which is going to be welcometothevault.com, so you can get updates on that. And we can go forward from there. But the average individual, the reason why I want to do this in this episode is because the average individual couldn't tell you the law that's applicable to calling themselves an international trust. They think just because they have a 98 number that they can actually, people that are, you know, and the people that know what I'm talking about, they know what I'm talking about. Oh, I have a 98 number, I can operate my trust offshore internationally. It doesn't work that way. I can share with you all laws deeper than what we even talked about, that if your entity is not written in a specific type of law and specific type of language, it can't even operate in other jurisdictions freely and privately. We're talking about operating freely and privately, not just operating because, oh, for operation's sake, and then doing it fraudulently or illegal. And in trustee training and asset protection training, we make it a point for you to know how to talk to the lawyers appropriate in each jurisdiction. Same thing with the CPAs. That's what we go over. So I just wanted to share that with you all. Offshore International Business Trust. You got to know the laws that's applicable to it. It's the Hague Convention on Trust. I think this came around in 1985, so it's been around for a long time now. And this is because wealthy people wanted to operate internationally, and they want to utilize the same contracts. Everybody's utilizing, for the most part, the same contracts. Just like all wealthy people have foundations. It's that simple. We're all operating the same exact way. So while everyone's filing a 1040, wealthy people are filing 1041s. It's that simple. It's just that simple. So thank you all for tuning in live or listening to replay. If you have any questions, feel free to ask quickly on the chat. Otherwise, I'm just going to wrap this episode up. Feel free to get on the list. Feel free to see you at the workshop. We're getting close to the end of the year 2017 here, so I definitely look forward to connecting with you all. We're going to do some more episodes here every single day for the month of December, and then we're going to wrap it up and take everything, put it on iTunes, make sure everything is up and running for you all, so you can have a continuous listening on a iPod experience, or what is that, a podcast experience, and you all can connect back on YouTube if you so choose to. But for the most part, just wanted to share this with you all. Hey, convention, hope you got some value out of this. Peace and blessings. Talk to you all soon. Trust Christian, own nothing, control everything.